Hello, everybody, and welcome to History / Law Bite number 312, dated September 29th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in. This History / Law Bite is entitled Zucht versus King, 260 U.S. 174, 1922. Zucht versus King, handed down nearly a century ago at the time of this recording, was a landmark U.S. Supreme Court decision that dealt with the constitutionality of required vaccinations before enrolling in schools, all right, whether or not there was a public health crisis and with the vaccine being administered, in a somewhat discriminatory format, all right? But before I begin, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. In addition to that, please also click the little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. All right. So, being that this is a U.S. Supreme Court decision, we begin in the same way the U.S. Supreme Court does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So we begin in Zucht versus King. Mr. Chief Justice, and may it please the court. So, in this case, the city of San Antonio, Texas, enacted local regulations to the effect that no children or other individuals could attend a public school or other place of education without having first presented a certificate of vaccination, all right? Accordingly, our petitioner here, Rosalind Zucht, was excluded from a public school in San Antonio by officials because she had no such certificate of vaccination and also refused to get one, okay? This exclusion, all right, had the effect, all right, of also getting her banned from a private school as well. Our petitioner refused to get a vaccination shot, and there was nothing anyone could do to make her get that shot, in her opinion, all right? So she was thus disallowed from attending the public schools here, all right? So because of her exclusion, Ms. Zucht would file suit in the Texas courts against the officials that had been responsible for her denial, okay? In her complaint, she argued that there was no situation going on in San Antonio or in Texas, in any case, that required her to get vaccinated, all right? She also argued that the regulations violated her liberty without due process of law under the 14th Amendment because vaccinations were mandatory, okay? That these regulations were void because they allowed the Board of Health the freedom to decide the time and circumstances to enforce these rules without any guidelines that they themselves had to follow, leaving no safeguards against bias and oppression, okay? And the relief sought included an injunction against the ordinances themselves being enforced, as well as a writ of mandamus compelling her admission to the public schools and for general damages, okay? Her claims would ultimately be dismissed by the trial court, and that dismissal was affirmed by the Court of Civil Appeals for the Fourth Supreme Judicial District of Texas, okay? So although certiorari was denied in the Texas Supreme Court, the case proceeded to the U.S. Supreme Court on a writ of error from the Chief Justice of the Court of Civil Appeals, okay? it was asserted that the ordinances violated the due process and equal protection clauses of the 14th Amendment, and as administered, they denied to the petitioner the equal protection of the laws. So the question presented to the Supreme Court of the United States was as follows. Did the San Antonio ordinances violate the 14th Amendment's due process clause right to liberty and, as administered, violate the 14th Amendment's equal protection clause? Okay? And the answer was a resounding no. In a unanimous opinion by Associate Justice Louis Brandeis, the court sustained the constitutionality of the Texas laws and affirmed the holding of the Texas courts. Referencing a litany of precedents to support its decision, the court ruled that it was perfectly legal under the 14th Amendment for individuals to be excluded from public schools due to lack of vaccination, and that the discretion given to local school boards was not arbitrary, folks, but only broad discretion that was needed to protect the public health. Okay? Justice Brandeis wrote that long before this suit was instituted, in Jacobson versus Massachusetts, which was handed down 17 years earlier. There's a separate video on that if you haven't checked it out. In that case, the court had settled the issue that it is within the police power of a state to provide for compulsory vaccination. All right? That case and others had also settled that a state may, consistently with the federal constitution, delegate to a municipality authority to determine under what conditions health regulations shall become operative. Laurel Hill Cemetery versus San Francisco, cited. And still others had settled that the municipality may vest in its officials broad discretion in matters affecting the application and enforcement of a health law. All right? A long line of decisions by this court had also settled that, in the exercise of police power, reasonable classification may be freely applied, and that regulation is not violative of the Equal Protection Clause merely because it is not all-embracing. All right? See Adams versus Milwaukee, Miller versus Wilson as well. All right? In view of these decisions, we find in the record no question as to the validity of the ordinance sufficiently substantial to support the writ of error. Unlike Yickwo versus Hopkins, 1886, these ordinances confer not arbitrary power, but only that broad discretion required for the protection of the public health. All right? So in sum, Justice Brandeis' opinion is saying, first of all, Ms. Zucht, it's long been settled law that it's within the police power of a state to require compulsory vaccinations. Okay, remember, Jacobson versus Massachusetts had held that very fact way back in 1905, 17 years before this decision was handed down. Okay, and next, he argued and referenced a long line of decisions that held that in the exercise of that police power, regulations in this manner did not violate the Equal Protection Clause requiring mandatory vaccinations if the state did not require everybody to have one. That, of course, means exemptions, all right? And as with most vaccination laws, there are some who may fall into the line of exemption. So, in other words, they don't have to get the vaccinations, all right? And so with that in mind, Ms. Zucht lost her case on both counts, all right? And thus the judgment of the Supreme Court was to affirm the holding of the Texas courts, all right? And so this case has had a long-lasting legacy, ladies and gentlemen, because it affirmed the ability, of local school boards throughout the United States and municipalities, whichever has the discretion to decide that matter, to require that children and others be vaccinated before enrolling. And of course, we see in light of the COVID-19 pandemic, Colleges and universities are also requiring the same thing, all right? You know very well, probably you yourself, I'm sure, have been vaccinated, against mumps, measles, smallpox, and other things. And you had to be vaccinated before you were allowed to enroll in school, all right? Elementary school, high school, so forth, so on, whatever the case may be, all right? But this case affirmed the constitutionality of all of that, all right? And put to bed any potential constitutional questions whereby people could rightfully and logically argue that a school had no right to do this. All right, the court put that to sleep, holding that the 14th Amendment did not in any way, stop a state, municipality, which is seen as being one with the state with respect to these local regulations, from requiring vaccinations, and it could apply them in a non-all-encompassing format. All right? So it is perfectly constitutional under the 14th Amendment, to require vaccinations prior to enrolling in school in the name of the public health, even if there is no public health crisis or no pandemic going on, and the vaccinations do not have to be administered to everybody. All right? So that is the holding of the court, and the regulations as described in this case, requiring vaccinations before enrolling and allowing certain people to be exempt, all right, did not violate any aspect of the 14th Amendment's due process or equal protection clauses. All right, so that's Zucht versus King, ladies and gentlemen, properly referenced as 260 U.S. 174, 1922. If you have any questions or controversies, please leave them down below and I will be happy to answer them for you. If you like this video, gain some insight or knowledge from it, of any kind whatsoever, drop me a like. Click that little like button. It means more than you'll ever know. And if you've not yet subscribed to my YouTube channel, Juarez Lee Shelton MA, please do so now. All likes and all subscriptions matter. Thank you so much again for listening. Take care, stay safe, and I'll talk to you at the next video. Peace.